Assalamu alaikum and a very warm welcome back to our channel, True Courtroom Stories. Today, we have something really special for you. What if I told you that a legal problem that absolutely dominates our headlines today, I'm talking about the issue of offensive speech, was actually tackled, and thoughtfully, almost 1,000 years ago? We're digging into a fascinating piece of legal history, and this is all based on the incredible research by Mr. Zahir Ahmad Mir for True Courtroom Stories. So buckle up, because we are traveling way back to the 12th century, to explore a challenge that feels, honestly, incredibly modern. And hey, if you enjoy these deep dives, please do us a huge favor and subscribe to our channel, give this video a like, and share it with your friends. It really helps us out. Just think about this question for a moment. When words cause offense, what is the actual role of justice? I mean, we grapple with this constantly, don't we? You see it in the lightning-fast, often brutal world of social media, you hear it in the heated debates in our own communities, and you see it being argued in the highest courts of the land. When speech crosses a line, what some people consider a sacred line, how is a legal system supposed to respond? It's such a delicate balance, and as we're about to discover, it is not a new problem, not by a long shot. All right, so to really understand the brilliant solution we're going to talk about, we first have to get a handle on the problem itself. Our story kicks off nearly a millennium ago, inside the powerful and absolutely sprawling Almoravid Empire. Now, this empire was massive. It stretched all across North Africa and deep into what we now know as southern Spain. So, inside their courtrooms, judges were facing these incredibly sensitive cases. We're talking about situations involving public insults or, even more seriously, alleged blasphemy. Now just try to imagine the kind of pressure they were under. Public emotions are running sky high, you've got crowds gathering outside the courthouse, and they're all demanding a swift and usually severe response. This created a huge legal dilemma. How in the world do you deliver justice that is both firm in its principles, but also fundamentally fair to the individual who's standing there accused? It's a real tightrope walk. And this is where our central figure, our guide through this complex issue, enters the story. To navigate this emotionally charged legal maze, we're going to turn to the wisdom of one of the most brilliant and respected legal minds of that entire era, a man known as Qadi Iyad. So let's place this man in time. Born in 1083, Qadi Iyad lived and worked right in the heart of this dynamic empire. And during his really distinguished career, he served as a judge in the vibrant cultural hub of Granada. This is important because it means he would have been presiding over exactly these kinds of challenging and contentious cases day in and day out. And just so we're all on the same page, let's clarify this term. A Qadi is a judge within an Islamic legal framework. Now, this is absolutely crucial to understand because it means Qadi Iyad wasn't just some scholar writing theories from an ivory tower. No, he was on the front lines making real-world decisions that had a direct and profound impact on people's lives and on the stability of the entire community. So, the big question is, how did he do it? How did he approach this incredibly thorny issue of offensive speech? Well, his solution was a principle that was, at its core, both simple and profound. And it would fundamentally reshape how these sensitive cases were supposed to be handled, creating a whole new standard for justice. He laid it all out in his landmark legal text, a book called Ash-Shifa. Now, instead of just focusing on the inflammatory words themselves, the surface-level offense that everyone was shouting about, he urged his fellow judges to look deeper. He told them to look at a far more crucial element, the speaker's state of mind. What was their intention? And this right here, this is the aha moment. This slide shows the core of his groundbreaking argument. He drew this sharp, crystal-clear line between two very different things. On one side, you have intentional blasphemy, a deliberate, malicious act designed to cause harm, to offend, to undermine. That, he argued, was a clear offense that the law needed to address. But on the other side, you have accidental speech, a slip of the tongue, maybe a comment that was misunderstood, or a statement that was just taken completely out of context. And in those cases, he demanded extreme judicial caution. So the key takeaway is this: it wasn't just about what was said, it was all about why it was said. That changes everything. And this single, powerful distinction, this idea of separating intent from a simple mistake, is the key that unlocks his entire judicial philosophy. It's a guiding principle of restraint, of careful, deliberate thinking over a raw, emotional reaction. Let's just pause on that for a second. Justice requires precision, not passion. Wow. In a time when a verdict could easily be swayed by public outrage, when the anger of a mob could literally dictate the outcome of a trial,
Qadi Iyad was pushing for a cooler, more analytical, and frankly, a much more difficult path. He was calling for a justice system that was grounded in facts, in evidence, and in deep inquiry, not one that got swept away by the powerful emotions of the moment.
So what does this actually look like in a real courtroom? Well, if you're a judge following this philosophy, it means you have an active, non-negotiable duty to investigate the speaker's true intent. It means you have to be extraordinarily cautious, especially when a case is stirring up a lot of public anger. The courtroom, in his view, had to be a space that was insulated from the passions of the street. The goal was to be like a surgeon with a scalpel, not a blacksmith with a hammer. Precise, careful, and focused on the truth, not on all the noise.
And believe me, this wasn't just some nice idea written down in a book. The consequences of this shift were profound. By putting precision before passion, Qadi Iyad's principle led to far more nuanced verdicts. It protected people who had genuinely made a mistake from the harshest penalties, and it made sure that severe punishment was reserved only for those with true malicious intent. This standard of judicial restraint became a foundational element of their legal practice, and it set a powerful precedent that lasted for a long, long time.
Okay, so you might be thinking, that's a really cool history lesson, but why does a 12th century legal principle from Granada still matter to us today? Well, the answer is because the fundamental questions he was wrestling with are still at the very center of our most contentious legal debates all across the world.
Seriously, think about it. The tension between protecting sacred values and allowing for human error, the crucial role of intent in deciding if someone is guilty, the very definition of the line between free expression and a punishable offense, these are not historical artifacts. They are living, breathing challenges for modern justice systems, showing up in fierce debates over hate speech laws and in blasphemy regulations that exist right now.
And we see this ancient dilemma playing out in very different ways in the modern world. For example, the source material points to Germany's laws against Holocaust denial. These laws don't just punish the words themselves. They specifically target the malicious intent to incite hatred and deny historical truth. Then, on the other hand, you have Pakistan's blasphemy jurisprudence, which often has to navigate these exact same questions of intent versus mistake that Qadi Iyad first laid out. So you see, both legal systems, in their own unique ways, are trying to walk that same difficult line.
And that leaves us with one final, very pressing thought. Qadi Iyad called for precision and for the careful examination of intent in a world of spoken words and handwritten manuscripts. We, on the other hand, live in an age of tweets, instant comments, and global outrage that can spark and spread across the planet in seconds. In our world, his call to judge intent over impulse feels more urgent than ever. It's a 900-year-old piece of wisdom that challenges all of us, not just in our courts, but in our daily lives, to bring far more precision and far less passion to how we listen and how we judge. Thank you so much for joining us on True Courtroom Stories. Don't forget to like, subscribe, and share.
All right, today we're going to do something a little different. We're not just looking at a topic, we're opening a case file. We're going to focus on a single, really profound legal puzzle that comes directly from our source material. So let's get into it. So our primary piece of evidence, our case file, if you will, is from this book, True Courtroom Stories, researched by Mr. Zahir Ahmad Mir. Now, everything we're about to unpack comes from just a single passage inside. Let's dig in and see what it actually reveals. Okay, so the source starts by pointing us toward what it calls a parallel case to illustrate a larger point, and that journey takes us straight to Germany. This is where the first clues to this whole legal puzzle start to pop up. Now we get to the core of the evidence. The source brings our attention to 3 very specific legal prohibitions in Germany. You can think of these as the key exhibits in our investigation, the ones that are supposed to show us where the boundaries of the law are drawn. Let's examine these exhibits one by one. First up, the denial of the Holocaust is legally prohibited. The law basically says, nope, this is a historical fact, and denying it is not allowed. Second, we have the glorification of Nazism. Now this goes a step further, right? It's not just about history anymore, it's about prohibiting the promotion of the ideology itself. And third, there's a broader prohibition against hate speech that specifically targets minorities. This is about protecting vulnerable groups in the here and now. Each one of these is like a pillar holding up a much larger structure. And here's the crucial point the source is making. These aren't just 3 random rules. The text implies they are intentionally connected, that they form the very backbone of a specific legal philosophy. They're designed to work together, to point towards one single unifying idea. The source has laid out the pieces of the puzzle for us. Now it's time to see the picture they create. And this is where our case file takes a really unexpected turn. Just as the source is getting ready to reveal the central idea, the one thing connecting all this evidence, it leads us right to the very edge of the explanation, and then it just stops cold. This is the final clue the source gives us. It simply says, the principle. And that's it. Nothing follows. The text just cuts off. An explanation is promised, but it's never actually delivered, leaving us hanging right on the precipice of the answer. And so, this is the central mystery we're left with. Our case file closes on a completely open question. The source presented the evidence, the prohibitions on Holocaust denial, glorifying Nazism and hate speech, and it clearly states they're all guided by a single unstated principle. So I'm going to leave this puzzle with you. What do you think that principle is? What's the one core idea that underpins this entire legal structure and makes it all make sense?
Hello and welcome. Today we're diving into a question that's as old as society itself. Where does free speech end? It's a conversation that shapes entire legal systems around the globe. We're going to unpack the complex legal and moral guardrails that exist, and our guide for this journey is the research of Mr. Zahir Ahmed Mir from his book, True Courtroom Stories. Let's get into it. So, right off the bat, this is the big question, isn't it? We all value freedom. But can any right, any freedom be truly absolute, with no limits at all? You know, every single legal system in the world has to perform this incredibly delicate balancing act between an individual's liberty and the need for a peaceful, functioning society. It's a constant push and pull, and that tension is exactly what we're going to explore today.
And this is where Mr. Mir's research really draws a line in the sand. The core idea here is that speech stops being free the moment it starts to threaten two essential pillars of civilization: societal peace, our ability to just live together safely, and the inherent dignity that every single person has. According to this legal philosophy, that's the point where the system has to step in. So, how does it do that?
Okay, so you have this big idea, this principle of protecting dignity. But how do you turn that into actual, enforceable rules? Well, that's where something called jurisprudence comes in. We're about to shift from the what if to the how to, from the big idea to the actual framework legal systems build to handle these incredibly tough issues.
Now, before we go any further, let's just get on the same page with this word, jurisprudence. I know, it sounds super academic and complicated, but it's really not. Think of it as the why behind the law. It's the philosophy, the set of guiding principles a legal system is built on. It's like the architectural blueprint that judges use to build their decisions. It's kind of like the conscience of the legal system. All right, to see how this all works in the real world, under some serious pressure, the source material points us to a very specific and often discussed area of law as a case study. We're going to be looking at the jurisprudence around blasphemy laws in Pakistan. Now, I want to be crystal clear here. Our goal is not to debate the laws themselves. It's to understand the legal process and the principles the courts in that system use when they're faced with these kinds of accusations. It's a really powerful lens for seeing a legal system grapple with that central question we started with.
So, within this specific legal context, Mr. Mir's research identifies a really clear framework that the courts have set up to guide them. He calls it the 4 pillars. And these aren't just suggestions. They are foundational principles designed to make sure justice is handled with extreme, and I mean extreme, care and caution, especially when emotions are running high and the stakes are, quite literally, life and death.
And look, these pillars aren't just abstract ideas in a law book. The source material grounds them in a real-world example, the case of Ayub Masih. This case is held up as a major precedent, a moment where the court showed incredible restraint. Despite huge public pressure, the court focused on one thing and one thing only, the evidence. They found it wasn't strong enough, and they acquitted him. It's a powerful demonstration of these pillars in action, acting as a brake against a potential rush to judgment.
So let's break these 4 pillars down, because each one is a critical safeguard. First up, strict evidentiary standards. This means an accusation by itself is never enough, not even close. The burden of proof is incredibly high, and it demands solid, verifiable evidence. It's the first firewall. Second, caution against false accusations. The courts are very aware that these kinds of charges can be used as weapons in personal fights, so they put the accuser's motive under a microscope. Third, and this is the bedrock of so many legal systems, the presumption of innocence. Every single person is considered innocent until proven guilty beyond a reasonable doubt. And finally, number 4, a total prohibition of vigilante enforcement. Justice belongs to the state and the state alone.
The law cannot be taken into the hands of a mob. You see how they all lock together? It's a system of safeguards. So when you put all those pillars together, all that careful process, it leads you to the central philosophical argument that holds this whole thing up. It's this powerful idea that there's a huge difference between freedom and license, and understanding that difference is absolutely everything.
Let's really look at this. On one side, you have freedom. This is the engine of progress, right? The right to share ideas, to debate, to question things. It builds things up. But on the other side, you have license. That's the demand for totally unrestricted action, the idea that you can say or do anything without any consequences. The argument here is that when speech is used to cause harm, to incite violence, or to just destroy someone's basic human dignity, it stops being a protected freedom. It becomes a destructive license.
And this all boils down to a core legal concept. It's a Latin term, ratio decidendi. All it really means is the reason for the decision. It's the ultimate takeaway, the fundamental rule that comes out of all these cases. And in this jurisprudence, this is it. Freedom is not license. And because of that, justice has two jobs: protect human dignity from being destroyed, and at the very same time, apply the most rigorous, careful scrutiny to every single accusation. That's the ultimate guardrail.
Okay, so we have been deep in the weeds of legal theory, right? We've looked at a really specific, high-stakes case study. But what does any of this have to do with us in our day-to-day lives? Well, this is where Mr. Mears' research zooms out to give us a universal lesson about the power that we all hold every single day.
And here's the crucial point. While we've been talking about formal legal systems, the underlying message is incredibly personal. It's about recognizing the awesome power packed into language itself. Every day, with every single comment, post, and conversation, we are all using that power. We're either building bridges or digging trenches. We're either healing or we're harming.
This final thought from the source material it hits the nail on the head. Our words can do one of two things. They can build up communities, they can create understanding, they can heal wounds, or they can tear people apart, fuel hatred, and destroy lives. The role of the law, in the way it's presented here, is to be that essential guardrail, to make sure this powerful tool we all have isn't used as a weapon.
So that leaves us with a challenge, and it's a challenge that goes way beyond any courtroom. In our world of instant global communication, where one sentence can literally circle the globe in seconds, how do we, as people, as a society, balance this immense power to speak with our shared responsibility to protect each other's dignity? That's the big question